with that, I would like to thank everyone who was here once again, and also thank everyone who competed in this competition, and also all the faculty members who wrote the problem, judged rounds. And I'd also like to thank the rest of the Moot Court Board, Santino, my co-coordinator, and Joey Stefanko, the Moot Court Chair, for all their help in this process. Once again, thank you, and with that, I will turn it over to Dean Rapp for a brief introduction.
So I want to welcome all of you to today's competition. If you would, please take a moment to silence your cell phones. And also join me in thanking John Young and Santino Cafarella, as well as for their hard work as Fornoff coordinators, as well as Joseph Stefanko in the back there shutting the door, for his work as Moot Court Chair this year. The Fornoff competition has a special place in this law school's history. Initiated by our students, it has for over 5 decades provided wonderful opportunities to hone legal research, legal analysis, and oral advocacy skills. Some lawyers have to learn the hard way that when the other side works harder and does more preparation, the other side wins. Not these competitors. I've had the chance to judge these students in preliminary rounds and practice rounds, getting them ready for today's competition, and I want to commend all of them for their achievement in reaching this stage of the competition. Today's competitors have put in a tremendous amount of work getting ready for this round, and while one of the teams will walk away as the round's winner, everyone who's on this stage today should be proud of the work that they put in. We've had great support this year from our Moot Court advisor, Kristen Beach, standing in the back, from law school staff, including Derek Dickerson up on the second floor, and Jody Birch, Rick Goheen and his team for arranging our audio and AV equipment, and our legal writing faculty led by Director of Legal Writing, Lisa Burns. The competition has a special place in the law school's history, but so does a person we owe particular thanks to, and that's Judge Carr. Again, this year, Judge Carr helped bring together a wonderful panel of judges to preside over this final stage of the competition. I'm going to turn things back over to Santino Cafarella to get things started. Thank you for joining us.
All rise. The judges of the Court of Appeals for the Sixth Circuit of the United States are now in session. Oyez, oyez, oyez. All persons having business before the Honorable Sixth Circuit of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The Honorable Judge Gentry, Judge Edmonds, and Judge Carr presiding.
Be seated. Call case. Or I can if you prefer. We're here for the case of Molson Coors Brewing Company, DBA Scaredy Cat Brewers versus Foundation Brewing Company. Counsel, please state your appearances for the record.
My name is Julie Lawrence, and my co-counsel Sarah Coach, and I represent Scaredy Cat.
My name is Tom Mispec, and I'm co-counsel and Anthony Ross, representing
If somebody could can you hear us all okay? Up in the balcony and so forth? Okay, because I know sometimes it's...
My voice is soft,
yeah,
so.
But may I only suggest, if you can't hear us or the competitors, go and say, speak up, okay? I don't think we'll be offended by that. It's too important for everybody, so thank you.
Appellant?
May it please the court, my name is Julie Lawrence, and I represent the appellant, Scaredy Cat Brewers,
a wholly owned subsidiary of Molson Coors Brewing Company, alongside my co-counsel Charlotte Gross. At this time, I would like to reserve 2 minutes for rebuttal. Thank you, Your Honors. This case involves a company who in 2021 created a new oatmeal stout called Good Morning Oatmeal Stout with the purpose and mission of bringing a craft brew experience to the average American beer drinker who does not indulge in the craft brew environment. This company is Scaredy Cat Brewers. In August of 2021, Foundation Brewing Company, the appellee, filed a complaint alleging trademark infringement of their federally registered mark, Morning Oatmeal Breakfast Stout. The ultimate question present in a trademark infringement claim is whether a typical buyer exercising ordinary caution is likely to be confused as to the origin of the products. This circuit ultimately uses an 8-factor test to determine whether consumer confusion is likely. However, in Homeowners Group versus Home Marketing Specialists, this circuit determined that these factors imply no mathematical precision and are simply to be used as a guide. The district court erred in affording summary judgment in favor of Foundation, and there is substantial evidence in the record in the present case that would allow a jury to find in favor of Scaredy Cat.
Counsel, on that issue, which specific factors of the 8 factors do you contend that there's a genuine issue of material fact to?
Yes, Your Honor. My co-counsel and I believe that there are genuine issues of fact present in strength of the senior mark and similarity of the marks, as well as evidence of actual confusion, marketing channels used, and intent of the defendant in selecting the mark. I will specifically be addressing strength of the senior mark and similarity of the marks, while my co-counsel will address the remaining factors.
Thank you.
As the Supreme Court stated in Anderson versus Liberty Lobby, genuine and material disputes of fact require a court to deny a motion for summary judgment. And Scaredy Cat respectfully asks this court today to reverse the grant of summary judgment afforded to Foundation and remand this case back to a lower court. As genuine issues of material fact exist, and there is no true indication that any buyer exercising ordinary caution will be confused. To begin, strength of the senior mark is arguably the most important factor, as it paves the way in how a court will determine how much protection is afforded to a mark. To find strength of the senior mark in favor of Foundation, Morning Oatmeal Breakfast Stout must be both conceptually and commercially strong. And Morning Oatmeal Breakfast Stout is not strong.
What does it mean? What does it mean to be conceptually strong?
Yes, Your Honor. The conceptual strength of the mark pertains to either the incontestable status of a mark, as well as determining whether the mark is arbitrary or fanciful, descriptive, generic, or descriptive with secondary meaning. In this case, because Morning Oatmeal Breakfast Stout is incontestable, it is at minimum descriptive with secondary meaning. However, in this case, the genuine issue of material fact pertains to the commercial strength specifically of Morning Oatmeal Breakfast Stout. And the commercial strength of this mark is heavily weakened by extensive third-party use of the senior mark and a lack of any evidence provided to Foundation supporting their claim of widespread public recognition.
What do you mean by heavy third-party use?
Yes, Your Honor. By third-party use, on page 52 of the record, Scaredy Cat provided the district court 27 instances of other registered trademarks that use the terms oatmeal and stout.
Together?
Yes, Your Honor.
Counsel, isn't the relevant unit of analysis the entire mark, not just isolated words? Don't we need to look at the entire mark?
Yes, Your Honor. This circuit does require a court to look at the entire mark. However, when determining whether third-party use does minimize the commercial strength of a mark, this circuit has specifically found that similar instances of third-party use is enough to potentially weaken a mark.
But there's something called the anti-dissection rule. Am I correct about that?
Yes, Your Honor.
Candidly, I'm having trouble understanding how can you apply that, because there are certain features that you look at. I mean, just tell me how that gets applied and how we can apply that rule without, in fact, violating it by looking at the color, the positioning of the names of the brewers, so
Yes.
forth and so on.
Yes, Your Honor.
The-
The
Looking to the, that sort of tannish brown, the backgrounds are the same, that sort of thing.
Yes. The anti-dissection rule does require a court to view the mark in its entirety as the mark is presented in the marketplace. For instance, a court cannot examine the mark side by side and pick apart bits and pieces of a mark. However, this circuit has determined that it is relevant to examine the individual features of the mark as well in determining how a mark is presented in the marketplace.
Isn't that fundamentally inconsistent? I see 3 sheaves of oat, I think they're 3 stalks rather than 2 stalks. I see tilted, so forth. I see similar fonts. I mean, seriously, I mean, how do you avoid, in effect, cutting it up?
Yes, Your
So
Honor.
why you have to look at sort of the totality of the, is it the totality of the impression on the viewer? What is it?
Yes, Your Honor. The totality of a mark is the impression on the consumer. Per the anti-dissection rule, it is correct that a court cannot take into consideration in the final analysis the individual features of a mark when comparing side by side. But a court can consider the individual features prior to their ultimate determination.
No, it's how they all add up in the end.
Yes, Your Honor.
Thank you.
Moving on to similarity of the marks. In the circuit, in Daddy's Junkie Music versus Big Daddy's Family Music Stores, this circuit has determined that this factor carries significant weight. However, the district court erred in their analysis by comparing the marks side by side and not in light of how they appear in the marketplace, in addition to failing to consider the presence of Scaredy Cat's housemark. In Daddy's, the circuit found that it was improper to compare the marks side by side. And the district court in this case ultimately determined that the marks are similar merely because they both contain the words morning, oatmeal, and stout. But when viewing a product alone, a reasonably prudent consumer is not going to be confused as to the origin of Good Morning Oatmeal Stout, because in this circuit, in AutoZone versus Tandy and Progressive Distribution Services versus UPS, the circuit determined that the presence of a house mark greatly diminishes any likelihood of consumer confusion, even when there are some similarities present in the marks.
You're relying on the fact that Scaredy Cat has Scaredy Cat Brewing on the top of it.
Yes, Your Honor.
Isn't that taking one little piece of information in violation of the rule, the anti-dissection rule?
For similarity of the marks, when viewing this factor, may I briefly conclude? The court ultimately focuses on the question of whether a mark, when viewed alone, will be confusing to the consumer. And per the anti-dissection rule, it does require a court to view a mark in its entirety. However, the circuit has held that the presence of a house mark does diminish that confusion.
If I'm going outside the record, say so, okay? But I think I almost take judicial notice of the beer display layout at Kroger's. It's a long, open session where there are dozens and dozens of different beers available. And isn't the purchase of beer sort of a glance and grab thing on, or am I going too far out of the record that you say, Judge, you can't consider that?
Yes, Your
But
Honor.
it just seems to me that, you know, whether these 2 six-packs are side by side or separated by 20 feet, sort of a glance and grab purchase. People don't spend a whole lot of time looking to see who the brewery is and so forth.
Yes, Your Honor.
Sort of impulsive. They know what they want. And if that's not outside the record, if I can consider it, aren't these marks so similar in their totality of appearance that without pretty careful scrutiny, an incautious customer might mistakenly grab the wrong product?
Yes, Your Honor. On page 32 of the record, the Vice President of Foundation did explain that Morning Oatmeal Breakfast Stout does have its own section dedicated to a product such as itself, along with other craft beers for consumers.
So there's a craft brew section and there's sort of a more general for more generally distributed beers?
Yes,
Okay.
Your Honor.
Okay, good, thank you.
Thank you, Your Honors. May I proceed?
You may.
May it please the court, and as my co-counsel stated, my name is Charlotte Gross, and I help to represent the appellant in this case, Scaredy Cat Brewing Company. Before I begin the bulk of my argument, I would like to re-emphasize for the court that none of the 8 factors used to determine likelihood of confusion are bright-line rules, which would suggest that these cases are inherently better for a fact finder and not for summary judgment. In Cunningham versus Laser Golf Corporation, the United States Court of Appeals for the Federal Circuit states that the likelihood of confusion is based on underlying facts, which would suggest that for summary judgment, the facts must weigh unequivocally in a plaintiff's favor, and that is absolutely not satisfied here. The 3 factors I will be focusing on are the evidence of actual confusion, the intent of the defendant in selecting the mark, and the marketing channels used. For the evidence of actual confusion, neither the record nor the case law supports evidence of actual confusion for the plaintiff here. I submit to the court that the only instance of actual confusion that the plaintiff has been able to produce is from an individual who saw a handwritten sign that said oatmeal stout and simply took the product. She did not take care to look at the label or anything like that.
Well, doesn't that kind of follow along with what Judge Carr was just asking your partner? In a setting such as Kroger, even if you've got a separate section for craft beer, somebody could just, and given that although there's a price differential, you're still talking about $9 as opposed to $14. You're not talking about $900 and $1,400. It would be easy for a consumer to be misled by one or the other.
Yes, Your Honor. In AWGI versus Trucking Corporation, this court stated that these factors go towards a consumer exercising ordinary caution, and the woman who was confused is not a consumer exercising ordinary caution. She is a member of a beer club. She tends to look at products in more detail, but she, for some reason, failed to do that this time.
In other words, the problem with that evidence, in your view, is it's simply a one-off, random event, and what they really needed to get was some sort of survey, whether it's, I don't know, how would one construct such a survey so that you could actually get, in effect, expert testimony, somebody to tell us how people make the choice between these 2 products, how they purchase it, so the whole array, whether Kroger nationally has the displays set up the same way and so forth. It just seems to me that as thin as that one-off incident is, and as unique as it is, why isn't it enough? What more could they have done to strengthen their case?
Well, Your Honor, in order to strengthen their case, they could have provided survey evidence. They have only produced one incidental piece of evidence, and in Flour Manufacturing versus Careco, the court correctly stated that short-lived confusion is not sufficient in order to weigh this factor in favor of a party, and that is the case of confusion we have here.
Counsel, isn't it true that the court needs to consider how long both products have been in the marketplace? Because if they've been in the marketplace together only for a short period of time, one would not expect to find very much evidence of actual confusion. I wasn't clear from the record, how long have both products been in the marketplace together?
They have been in the marketplace individually. Foundation's product has been in the marketplace since 1995. Scaredy Cat's product has been in the market since 2021. However, they have only recently been sold in the same store, which is Kroger, in the past 12 months at most.
All right.
Excuse me, Your Honor.
Could they have gone to Kroger and perhaps subpoenaed evidence in terms of comparative sales between the 2, and at least develop some sort of evidence, the extent to which, in fact, their product is chosen over mobs?
Yes, Your Honor. In fact, we do have survey evidence that supports our case here
from a gentleman named Darren Stevens, who's a marketing expert and a Harvard graduate. He states on page 41 of the record, I believe it is page 41 of the record, that there is a statistically insignificant likelihood of confusion between these two products. We have the survey evidence. My esteemed opposing counsel does not have any survey evidence to support their side for this factor.
So would you say that because there's conflicting evidence, there's a disputed or genuine issue of material fact that should preclude summary judgment?
Yes, Your Honor. And because this evidence of actual confusion does reflect what's happening in the marketplace, this absolutely at minimum creates a genuine issue of material fact, if not weighing this factor completely in favor of my client.
And isn't that really the core issue in this case? When you
Uh,
get right down to it?
The genuine issue of material fact?
Yes.
Yes, Your Honor.
Yeah, and that your response is simply, look, we've got at least more significant and scientifically or empirically based, data-driven, data-created, as opposed to the one-off incident of a particular kind of consumer.
Yes, Your Honor.
And at the very least, in your view, trial court should have examined that and said, there is a disputed issue of material fact, and this case cannot go out on summary judgment.
Yes, Your Honor.
That's the core, the kernel of your argument, right?
Yes, Your Honor.
Go ahead, continue.
Sorry. Furthermore, Your Honor, in Champions Golf Club versus the Champions Golf Club, this court stated that 4 instances, recorded instances of customer confusion was insufficient to weigh this factor in favor of the plaintiff, and here we only have a quarter of that, so therefore it should not be sufficient to weigh this factor unequivocally.
Your client relies on, you rely on the affidavit of Deshaun Gordon.
Yes, Your Honor.
It's unclear to me how he could ever show evidence of actual confusion. He testifies that he saw none, but his store only sells the one beer, the Mob's beer.
Yes, Your Honor. We also have an affidavit from Darren Stevens, who is the marketing expert I mentioned before. It is true that Deshaun Gordon's store only sells morning oatmeal breakfast stout, but the affidavit we have from Darren Stevens does help to mitigate that for our case.
But doesn't that go to the weight of that evidence, which again is more appropriately for the fact finder to determine?
Yes, Your Honor. The trial court itself did not explicitly state that evidence of actual confusion would weigh in favor of the plaintiff. They stated that the evidence could favor Foundation slightly and not that it weighed unequivocally in Foundation's favor, which helps to create a genuine issue of material fact as to this factor.
And isn't that statement itself indicative of error on the trial court's part?
Yes, Your Honor, I would say so with all due respect to the trial court.
I better start arguing for the trial court. Judge Carr is doing a pretty good job of tearing it down.
My heart may not necessarily be in that exercise, but that's quite all right. Go ahead. You may continue, counsel.
Thank you, Your Honor. As for a genuine issue of material fact for the intent of the defendant in selecting the mark, the lower court on page 63 of the record stated that the evidence on the question of intent was mixed. Going to an earlier points that we have discussed, that phrase in and of itself creates a genuine issue of material fact. If the court disagrees with this, the case law further supports that there is a genuine issue of material fact as to this case. Wynn Oil Co. versus Thomas states that in order for this factor to weigh in a plaintiff's favor, they must show that there was intent to capitalize on the part of the defendant. And there is absolutely no evidence of that here. In fact, on page 28 of the record, there are emails from the head of marketing for Scaredy Cat that referred to Foundation's product, and I quote, as frou-frou crap, end quote, which would suggest at minimum a pejorative view, if not a disdain for their product.
But isn't it possible to read that email as expressing a concern that the two products would be confused, and that your marketing person didn't want the new product to be confused with the other product, and that was why they were concerned about the similarity of the name? So I feel like that evidence actually hurts your client quite a bit.
I respectfully disagree, Your Honor. I don't think that it hurts our claim because they say that they don't want it to get confused, that there was concern and there were steps taken to not capitalize on Foundation's product. In Commercia Incorporated versus Fifth Third Bank Corporation, The court correctly states that awareness is not sufficient to show intent, and here the only evidence that the plaintiff has been able to produce is that there is awareness of the mark and not that there is intent to capitalize. At minimum, the opinion of the lower court shows that there is a genuine issue of material fact as to this element, and that summary judgment was inappropriate in this case. The marketing channels used by a company, may I briefly conclude? Yeah. For the reasons listed by myself and my co-counsel, we respectfully ask the court to reverse and remand this for further proceedings. Thank you.
Thank you, Ms. Gross.
May I proceed?
You may.
Good afternoon, and may it please the court. My name is Colin Mischek, and my co-counsel and I, Cindy Voss, represent Foundation Brewing Company. Today, we are asking the court to affirm the lower court's ruling of summary judgment due to there existing no genuine disputes of material fact. Opposing counsel has said that because of the fact-intensive nature of this case, a fact finder is better suited. However, I would like to point the court's attention to a Sixth Circuit case of WSM Incorporated, where the court said summary judgment in a trademark infringement case is just as appropriate as any other case. So long as Foundation, as my co-counsel and I plan to do, properly argues a summary judgment motion, it should be granted.
Counsel, isn't it possible to read the trial court's opinion as misapplying the summary judgment standard because the trial judge did not actually consider whether there were genuine issues of material fact as to any of the factors? He simply made his own findings of fact.
Well, Your Honor, I would answer that question in that the standard of review is de novo. So if this court were to find that a factual finding possibly incorrect, then they can do that. However, the ultimate question for this court today is whether or not there is a likelihood of confusion, and therefore that's a legal conclusion, and that would be it, Your Honor. Does that answer your question?
But aren't there certain facts that have to be determined somehow, someplace, sometime that underpin that ultimate conclusion of law? And isn't that what we've been talking about so far?
Yes, Your Honor. If I'm understanding your question correctly, it's whether a likelihood of confusion is a legal question or not.
Yes, but aren't there certain factual findings that have to be made by somebody? In this case, the trial court, I believe, did that fact.
Yes, Your Honor.
Made those findings.
And our position today is that the factual findings in the record are substantial enough to still weigh in favor of Foundation, and the legal conclusion is also sufficient enough to weigh in favor of Foundation.
So in other words, it's your contention that had this case gone to a trial, the decision was foreshadowed.
Yes, our contention today is that a reasonable jury would still not find in favor of Scaredy Cat Brewers, and the lower court got the decision correct.
Okay.
Today, I will discuss the factors of similarity of the marks, the strength of the senior mark, and relatedness of the goods. My co-counsel, Cindy Voss, will speak of intent, the marketing channels used, the evidence of actual confusion, and degree of purchaser care if time permits. Beginning with the similarity of the marks, as Your Honor had questioned opposing counsel about, the anti-dissection rule exists in the Sixth Circuit. This has been seen in the Daddy's Junkie Music case. As opposing counsel has also said correctly, the anti-dissection rule has mainly worked in that the court will look at the individual aspects of the mark, and then they will determine whether or not the conflicting marks give the same overall impression. So the marks in this case have a tan background, they have 2 oak stalks, they have a steaming bowl of oatmeal, they use the same black cursive script. Therefore, the case law, such as in Daddy's Junkie Music, would indicate that both of these marks give the same overall impression. And speaking directly towards opposing counsel's argument
Is that
of
the overall impression to us as judges looking at the 2 labels, or is it to the beer purchaser?
it would be, as seen in the Daddy's Junkie Music case, it would be to a consumer with a general, vague, or even hazy impression of the marks.
And where is the evidence in this record that tells us about what the general consumer with a hazy impression of these two marks?
So the evidence in the record would best point towards our evidence of actual confusion, where there has been a reported incident, and that would speak more towards the evidence of actual confusion factor, which my co-counsel Sydney Voss would explain. Moving forward to the house marks at the top of the marks. Scaredy Cat has their house mark at the top, while Foundation has our house mark at the top as well. However, the Sixth Circuit has said, such as a case of the Thermoscan case, that the house mark at the top is not enough to rise to the level of a genuine disputed material fact. It is said that if the marks bear many similarities or give the same overall impression, the house mark will only serve to slightly diminish the weight of the factor. However, as seen in that Thermoscan case, that court still ruled that the similarity of the marks, this factor, is going to weigh in favor of the senior mark, and that case is very analogous to what we have here today. The house marks are different. However, 3 out of the 4 words in both of our marks are the same, and as I've previously mentioned, the tan background, the oak stalks, the cursive script bear this factor to still favor Foundation despite the house marks being different. Moving forward to the strength of the senior mark. Directly answering opposing counsel.
And aren't the words that matter here oatmeal stout?
Yes, that is part of the mark. However, Your Honor, as seen in the record, our trademark is both the words morning oatmeal breakfast stout and the logo. So therefore, what the court needs to analyze is whether or not the logo and the words are similar. And so, in speaking towards the third-party marks and the strength of the senior mark, as you mentioned, Your Honor, the words oatmeal and stout, our contention today is that the Sixth Circuit, as seen in the homeowner's case, will look at whether or not the 2 conflicting marks use similar words. However, it's not enough to just show mere existence of third-party marks in the marketplace. The opposing counsel or the infringer has to show evidence that there exists in the world other trademarks that both use oatmeal and stout, but then also have the same logo as us or a similar logo. The court is not looking for marks that just use the same words. They're looking for marks that actually bear a resemblance to the senior users. Scaredy Cat has provided no evidence of any marks besides their own and ours today that bear any resemblance to each other. This court has said in the Daddy's Junkie Music case that just because marks can use the similar words does not mean that the senior mark is automatically weak. Therefore, the infringing mark will need evidence that, for example, in this case, we would need evidence that there is another oatmeal stout out there that has a tan background, that has a bowl, that has stalks. There is no evidence in the record to indicate that.
Isn't the word oatmeal considered descriptive? Oatmeal stout is a category of beer. Morning breakfast is just, you could put it on cornflakes or whatever. But the argument that was made about 19 other beers having the words oatmeal stout, maybe morning was included in that too. How does that impact your case?
So, Your Honor, we actually feel that that helps our case. As seen in the Win Oil case, this mark has been given descriptive with secondary meaning conceptual strength status. The Win Oil court had said that when a mark has a descriptive with secondary meaning combined with what is the incontestable status of a mark, which our mark has achieved due to being federally registered in 1995 and no successful challenges within the first 5 years of usage, those 2 factors of incontestable status and descriptive with secondary meaning indicate that our mark has a presumption of strength. And the only way to combat that would be third-party usage of marks. However, as I have explained, the third-party marks that opposing counsel has brought up, this court has ruled insufficient to make a mark weak or be present as a genuine dispute of material fact. Finally, speaking more towards the incontestable status of the mark, once again, it is a successfully federally registered trademark, and there was no challenges in the first 5 years. We want to point the court's attention that we have been in the business for 23 years. We have never had a trademark infringement case until today. Speaking directly also to opposing counsel, the contention was that the marks have been in the marketplace with each other for 12 months. However, that directly conflicts with the record. Good Morning Oatmeal Stout was introduced in August of 2021. The actual confusion was on October 7th, 2021, and the lawsuit was brought at the end of October of 2021. Therefore, these products have been in the marketplace for only 2 months before we brought this.
And
And
we
that-
don't know how the confused purchaser happened to go shopping in the, let's call it the generic oatmeal stout market rather than the craft brewery, do we?
Correct, Your Honor. And may I answer your question?
Says stop.
Yeah, and doesn't that itself raise an issue of fact as to the credibility of that affidavit, which is, of course, the only affidavit in the case?
May I
of
respond, Your Honor?
confusion. Pardon?
May I respond? Sorry, my time is
Yes.
gone. Thank you. So to answer your question, Your Honor, no, because the case law in the Sixth Circuit has said that the evidence of actual confusion is actually not needed. The Win Oil case had 0 cases of actual confusion, and due to this being a multi-factor balancing test, the totality of the factors still weighed in favor of the senior user. And my opposing counsel, as I will turn it over to, will speak actually more directly of evidence of actual
Your
confusion.
co-counsel, I hope.
Co-counsel.
not your
Oh, yes.
Not opposing counsel.
Thank you for your time, Your Honor.
You've been switching sides on the way up, I assume.
May I proceed? Good afternoon, Your Honors, and may it please the Court. My name is Sydney Voss, and I too represent the Applee Foundation Brewing Company, alongside with my co-counsel, Colin Mischek. Again, we're asking the Court to affirm the grant of summary judgment awarded to Foundation at the District Court level because there's no genuine dispute of material fact, and a reasonable jury could only find that there is a likelihood of confusion among consumers. We want to reiterate for the Court that although facts need to be considered in this analysis, it does not preclude a court from ruling on summary judgment. This is a case about trademark infringement, in which there is a balancing of 8 factors in order to determine a likelihood of confusion among consumers. The District Court properly weighed the evidence in the light most favorable to the appellant and came to the proper conclusion for summary judgment for Foundation. Foundation wins on 6 of the 8 factors, the other 2 of which were found to be neutral and not significant in the overall analysis at hand. Again, this is a balancing test of which no factor is dispositive in finding for a likelihood of confusion or not. Based on the evidence presented in the record and the District Court's correct assessment of that evidence and the analysis of the factors, we urge this Court to uphold summary judgment. The first factor I'll be discussing is the intent of the defendant in selecting the mark. And as my opposing counsel mentioned, the record is rather unclear about the intent of the defendant. However, the District Court found that this factor weighs neutral because there is no strong direct evidence of intent. However, argues that there is circumstantial evidence of intent, which is enough to find this factor to weigh in favor of Foundation.
Isn't it important to let a jury decide that issue, especially if it comes down to credibility or if the evidence of factual intent is ambiguous?
Your Honor, to answer that question, while the record is unclear and while a jury may need to decide whether or not intent, this factor, there is evidence to suggest intent, the District Court was correct in finding that this factor is neutral and doesn't weigh significantly because of the unclear evidence, so there is no reason for a jury to decide this factor.
And obviously, context in which that email was sent is important, but there is no evidence produced of the context, and that's the burden of the person who wants, the party that wants to rely upon that as an expression of intent. Is that correct?
Yes, Your Honor. In the Win Oil Company case, which was in this circuit, the Sixth Circuit, they said that the good intentions do not preclude a finding of likelihood of confusion. And we do not even have that here. We don't have any evidence of Scaredy Cat's good intentions. Furthermore, in this circuit, in the AWGI case, the court found that the defendant's knowledge of the plaintiff's mark and a failure to exercise diligence when using a similar mark was circumstantial evidence of the intent to benefit from using a similar mark. So that's exactly what we have here. We have a Scaredy Cat email chain between two parties within Scaredy Cat that express that they have knowledge of Foundation's mark, and the parties in that email recognized the similarities between the two marks and did not exercise diligence thereafter to use a different mark that was not similar to Foundation's. And again, in the Sixth Circuit, in the Progressive case, this court also stated that circumstantial evidence of copying, particularly the use of a contested mark with knowledge that the mark is protected, was sufficient to support an inference of intentional infringement where direct evidence is not available. Again, this is exactly what we have. We do not have direct evidence, but we do have circumstantial evidence. Therefore, we argue that this factor should have been weighed in favor of Foundation, but at the very least should be considered neutral if Your Honors decide so, and is not significant in the overall analysis at hand. Therefore, Foundation still wins in the overall analysis on 6 of the 8 factors. So moving on to factor 4, which is evidence of actual confusion. The district court again found this factor to be neutral. However, again, we are arguing that this factor should have weighed in favor of Foundation because even if we have produced one incident of confusion and it was not enough to weigh this factor in favor of Foundation, Foundation still again prevails on summary judgment. We are arguing that our evidence is we are arguing that the evidence, based on the evidence, this factor should weigh in favor of Foundation. The court in Daddy's Junkie Music in the Sixth Circuit said that evidence of actual confusion is the best evidence of a likelihood of confusion. The Sixth Circuit also said in the Wynn Oil Company case that a lack of evidence is not sufficient in finding for the defendant, and the court also acknowledged that evidence can be hard to produce. Also in that case, they said that 0 instances of actual confusion was enough to find a likelihood of confusion. So again, that's exactly what we have here. We have 1 instance of actual confusion, and it should have been enough to weigh this factor in favor of Foundation. And as my
You've been talking about evidence of incidents of the 1 incident of actual confusion, but I understand the test to be that you need only show the potential for actual confusion, not actual confusion itself.
Yes, Your Honor. And while that is correct, and so to get back to the point of the Wynn Oil Company court, they said that 0 instances was okay and was still enough to find a likelihood of confusion overall. So although actual evidence is the best evidence of a likelihood of confusion, this court does not require that the senior mark produce it.
Does Scaredy Cat's survey evidence create a genuine issue of material fact on the issue of actual confusion?
Your Honor, it is our position that the survey evidence does not create a genuine dispute of material fact because we can use numbers and math to say that actual confusion shouldn't happen or it couldn't happen. However, it did, and a reasonable jury could only find that actual confusion occurred.
But
Go ahead.
I'm sorry. In the survey, they reached out to people and asked them questions and did a demographic analysis. So why couldn't a jury rely on some of that evidence to reach a conclusion about actual confusion or the potential for confusion?
Your Honor, I agree with what you are saying. However, in this case, we do have actual confusion. Therefore, this survey doesn't necessarily undercut, and it at most would render this factor to be neutral because of the conflicting views and not significant in the overall analysis then. So going back to the factor overall, we have our evidence on the record at page 42 is the affidavit of Petra Hayes, who is a beer enthusiast and intended to purchase Foundation's product and ended up purchasing Scaredy Cat's product instead. She reached into the cooler, she recognized the familiar warm brown color, the oat stalks, the bowl, and the word oatmeal. Then she ended up purchasing the wrong product, and it wasn't until later that she realized she had made a mistake. So her familiarity with Foundation's product and the similarity of Scaredy Cat's mark to Foundation's mark is what caused her confusion. At most, this factor weighs in favor of foundation, and at the very least, as we've discussed, Your Honors, it's neutral and it doesn't weigh in the overall analysis at hand.
Given that what I would consider the paucity of evidence as to actual confusion and as to intent and so forth, doesn't all of this inevitably lead us back to looking at the labels and making a judgment? Or shouldn't, or more properly put, shouldn't all of this have led the court to say, hey, this is something for the jury to decide? But isn't ultimately the core of all of this looking at the labels, their composite parts, and then the overall impression that is, as a whole, that is given?
Yes, Your Honor. However, the district court did just that, and they found that there was no genuine disputes of material fact, and this was not proper for a jury to decide whether or not there was a likelihood of confusion. Based on what you have just reiterated, is that this was proper for the court to do so, and that's what they did. They ruled on summary judgment, and there was no need to go to a fact finder because of the marked similarities of the two marks and the obvious idea that there could be a likelihood of confusion among consumers. So moving on to factor 5, which is the marketing channels used by the two companies. The district court found that this factor weighs in favor of foundation due to the overlap in foundation and Scaredy Cat's distribution channels. And obviously from the record, we know that there is a clear and direct overlap in sales at Kroger in a number of different states. This circuit has said in the Wynn Oil Company case that the court must consider whether or not the approach of the parties resemble each other. And here they do. Both parties market through social media. And in the Daddy's Junkie Music case, the court found a likelihood of confusion even though the advertisements differed. The court concluded that overall the two parties were marketing the same product. And again, this is exactly what we have here. Although marketing channels and marketing advertisements may differ in some respects, but not entirely, overall, the two parties are marketing the same product, an oatmeal flavored beer.
Would your case be weaker if Scaredy Cat was not marketing through Kroger?
Perhaps, Your Honor, perhaps it would change the, may I briefly conclude?
You may.
Perhaps it may change the overall weighing of this factor, and even so, if this factor did tip in favor of Scaredy Cat, foundation still wins on 4 of the other factors, and thus overall winning in the analysis. And just for these purposes, but for the reasons stated by both myself and my co-counsel, we urge this court to uphold summary judgment. Thank you.
Thank you.
Thank you, Your Honors. A trademark infringement claim is a mixed question of fact and law, and this circuit specifically in Kibler v. Hall determined that a trademark infringement claim is so inherently factual that summary judgment is rarely granted. Foundation has provided no direct and no circumstantial evidence in support of their claim of a likelihood of consumer confusion. Their one instance of actual confusion that they submitted to the district court has been deemed de minimis by the Sixth Circuit, specifically in Leilano Wine Cellars versus Black and Red. The Sixth Circuit stated that anecdotal counts of confusion are deemed de minimis and have been declined to be substantial. In considering the district court's conclusion that evidence of actual confusion is neutral, the district court considered Scaredy Cat's survey evidence showing no likelihood of consumer confusion and found the survey to be valid evidence. However, the district court found this factor was neutral because of Foundation's anecdotal count of confusion. When considering anecdotal counts of confusion are de minimis, a reasonable juror can only conclude no likelihood of consumer confusion based on the probative evidence Scaredy Cat provided to the court showing no likelihood of consumer confusion. In addition, when looking at the intent of Scaredy Cat in selecting Good Morning Oatmeal Stout, there is no clear intent present in the record as to why Scaredy Cat chose their mark. And a reasonable juror can look at the email chain in the record and find an actual lack of intent. Scaredy Cat did not want the products to be confused. Yes, Your
I
Honor.
mean, at the end of the day, what we're talking about, I believe, is that the contention that mob sales have been adversely affected. The sales generated at Kroger's, could they not have brought, or at least undertaken a study of the sales of mobs before Scaredy Cat showed up, before Good Morning Oatmeal showed up on the shelves? And what if that survey has shown mob sales will hold pretty steady? People buying oatmeal, Good Morning Oatmeal Stout, but isn't the ultimate question is, have you actually been adversely affected, and if your sales haven't diminished to any significant or perceptible extent, so what? That's showing that consumers are not confused.
Yes, Your Honor. However, there is no evidence in the record provided by Foundation.
So is it your contention essentially that they haven't met their burden of proof on the claim?
Yes, Your Honor, and Scaredy Cat has provided substantial evidence pointing to no likelihood of consumer confusion. Thank you, Your Honors.
Thank you. I believe that concludes the arguments, and we are supposed to step out and deliberate.
All rise.
You all may be seated. And if we could get a round of applause for all of our competitors for their great work. So we'll now have a little bit of a break in the action while the judges deliberate. When they return, they will announce a verdict for both best team and best individual oralist. In the meantime, please make sure you sign in the back if you have not done so already, and please eat pizza before it falls on Santino and I to eat it all. So go on back and do that. Thank you all for being here again.
Never again. I just
All rise. May be seated.
So this is the hard part for us. The other part was just fun. First, I want to say that it was truly a pleasure to be able to preside over four such outstanding arguments, so well prepared, so really knowledgeable of the law and the facts of the case, and so sophisticated in your ability to answer questions and not deflect. All four of you did just a terrific job, and I think although one side wins and the other doesn't, that you should feel like you really represented your client to the best of your ability and did a great job.
There were no losers.
No losers. Except that we, there is.
Well, I wish we had a fourth member of the panel, then we could split evenly and we'd go home, okay? But can't do that.
And in fact, we have decided that the appellant wins on the legal issue. And the much harder decision for us was which team and which of the four of you for best oralist. You all deserve it, and we would feel good about awarding it to any one of you. But since we have to make a choice, we award best team to the appellants and best oralist to Charlotte Gross.
And it came to be a unanimous decision, but it took some discussion, which is real life, the way it works in the Court of Appeals. So, good.
So thank you all for participating in this. I had no idea that you were freshmen.
You are freshmen, right? First years? Oh, you're not?
Oh,
Okay.
two Ls.
I'm sorry,
Okay.
my mistake. I thought it was
And-
first year competition. My mistake.
You did a great job, and it was a lot of fun for us to preside. Thank you.
Uh, On a personal note, it's my firm conviction that the only way that the quality of life in our increasingly third world country, in my 82 years, the only way indisputably that the quality of life has improved is beer. Okay? And I am a dedicated IPA drinker. I enjoy, and there's lots and lots of varieties. And this case was particularly interesting for that reason, none other. I had some familiarity with the core subject, not with the law, but with the core subject. And go ahead.
And my son is the part owner and chief brewer, head brewer of a very successful craft brewery in Portland, Oregon. So I'm pretty familiar with the beer industry myself.
And I'm going to ask my colleague, go ahead and brag as she did to us, just how successful has he been recently?
There's a competition called the Great American Beer Festival, which is the biggest international beer festival in the world. Every year they have it usually in Denver. And my son's brewery this year won 4 medals, 3 gold and a silver, more than any other brewery in the world. And the silver was for his American Style IPA, which was the largest category of any of the 106 categories of beer that competed. Breakside beer. It's in Portland,
Well,
Oregon, not,
Go ahead. I'm
they
sorry.
don't distribute in Michigan or Ohio.
Or Massachusetts, where I happen to live now. And I only say I've been to Portland on a few occasions, and it is a beer lover's heaven, okay? It was really one of the hot spots that initially generated this marvelous explosion and expansive varieties of beer that at least I enjoy. I, from time to time, have German students who find my way into my chambers for a semester, their last semester of 7 years of law school. And consistently, over the past decade or so, or longer, 15 years, they have said that American beer is better than German beer. And they say it sincerely. So congratulations to entrepreneurs and like your son, making the quality of life in this country so much more enjoyable and pleasurable for some of us, okay? Now, I just want to ask that these competitions are always fun, and I've sat off and on over the years. I have the pleasure of inviting colleagues, friends on the bench whom I know and admire for their jurisprudential qualities, their intelligence. They're willing to work at something like this. It's always daunting as a judge, anywhere, anytime, to be firmly convinced that the advocates know more about the case and the law than you ever will, which of course is common. We spend as much time as we can preparing, each of us on our own caseloads, but at the end of the day, that's the way it should be. If you aren't convinced that you, in fact, in this case, in this instance, know about the pertinent facts, the actual legal doctrines, and why you should win the case, then tell your client to look elsewhere, because that's really crucial, I think. And you folks really clearly met that standard.
I also want to commend the finalists and commend all of you who participated in the competition for taking the time to do that. It wasn't required that you do that, but I think it is a terrific preparation for being in practice. I was in private practice as a litigator for nearly 25 years before I became a judge. I argued in front of the Sixth Circuit probably 6 times, and I was equally terrified before every argument. But the one thing that did change from my first to my last argument is that I became more confident in myself. And so the more that you can get up on your feet and argue and be in front of judges, the better you'll feel about, your own abilities. So practice makes perfect, and congratulations to all of you.
Becoming a capable oral advocate, whether in the trial court, in the conference room, or wherever, it's just like learning to swim. You got to do it to learn how. There's no other way of learning how to become a capable, competent advocate than actually doing it, and which makes this program particularly fun to see consistently how far along the competitors are, the finalists here at the University of Toledo. And I just want to close my own remarks by telling all of you in the audience how friendly you make this former professor feel. I was a professor here from 1970 to 79 by sitting as far away from me as humanly possible. Thank you.
All right, thank you all. And we'd like to also thank the judges for being here. We have a little token of our appreciation for all 3 of you.
Thank you. Beer.
I don't know, Professor Beach, is there beer in there?
Good. Really? I thought you said yes. Oh. Thank you very much. It's always a pleasure to be back. Thank you. Good.
All rise. All right, thank you all for being here. Have a great rest of your afternoon.